Hello, this is Brent Bragg from CrowdEngine. We're joined by Marty Tate from Carmen Linoff and Israelson. We'd like to welcome everyone to this month's The Legal Hour with Marty Tate. To start this month, we have a question regarding broker-dealers, and could issuers offer their own offerings via 506C? Marty, what are your thoughts?
First of all, nice to be here, Brent. It's actually snowing here in Utah, which is great. So, going to your question, can issuers offer their own offerings under a 506C offering? Absolutely. So, I think that this came in from one of the participants, and they were trying to make the distinction between the prohibition under Regulation CF or a 4A6 deal that prevents or prohibits platforms or licensed intermediaries from having a financial interest in the issuers on their portal. As we've discussed, I think, in previous podcasts, a licensed portal doing offerings under Reg CF cannot have a financial interest in one of their issuers. And the exception to that is they can take equity compensation in an issuer as part of their, their compensation for having it on the portal. We can contrast that with a platform that is doing offerings under 506C or Title II. There is no similar prohibition in those deals. So if you have a platform and you want to put your deals up on it and offer it only to accredited investors, there's no problem with that. I think the only real issue with that is you need to disclose, interests that you have. If you're trying to market yourself as this sort of third-party, funding platform, you would need to make sure that you disclose your interest in the issuer. If it's your company or if you have a financial interest in that company, I'd want to make sure that that's disclosed so that nobody could come back to you and make a claim that they didn't know or that there was a conflict. Typically, you would disclose that. I would probably disclose that on the platform as well as in any offering documents or materials that you provide.
Perfect. So now's the time to write your questions to Marty, and I will facilitate those questions. Our first question comes, can you please discuss the marketing limitations of a Reg CF platform or Title III platform and their offerings?
Yeah, so
there's a lot of confusion of, what could I say with 506B? What could I say with Reg CF? And how does that contrast with Regulation 506C versus B, and then also Reg A+?
Yeah, so, all right, you cover it all there.
We'll start with Title III.
Brent likes to start one question and then
blossom into many.
And then throw in like 6 appendages to that, but I'll just go right back at you with a run-on answer. How about that? So under a Reg CF, you are an issuer and a platform are limited in what they can do, and there is a slight distinction between what the portal, the funding portal can do, and what an issuer can do. And there's some similarities and then there's some slight distinctions. One of the things that, with respect to advertising under Reg CF, I got this question the other day, is, hey, well, what can we do before we launch? The answer is nothing. Well, not nothing, but you have to be careful not to very limited to condition the market, which means, if you start ramping up your advertising of your product, no, you can advertise your product, you can continue to do your marketing campaigns. You cannot say anything about the offering or anticipated offering. I had a client say, well, hey, can we let people know that, we're going to be starting this soon? No. Can you let people know, your customers know that, there's an exciting opportunity that's coming? Probably not. But can you continue to market your product? Absolutely.
So you could market your brand saying, we are a Reg CF portal and we will have deals of this type.
Well, let's back up, because again, that's the portal, right? I'm talking about the issuer. So say I'm an issuer.
So let's start keep on the portal level. What could the portal do while they're building their portal, while they're getting things ready, while they're finding issuers? How do they market and put themselves on the map if they can?
So they could, there's nothing that prohibits the portal itself from marketing or from trying to advertise. I think the key there would be they have to be very careful to shy away from, until they're licensed, until they're approved by the SEC and FINRA, from saying that they are a funding portal or a licensed intermediary or any one of those buzzwords that would get them in trouble until they're actually licensed. But they could go out and say, hey, this is who we are. We plan to facilitate offerings under Reg CF. We're applying. There's nothing that would prohibit them from doing that. Once they are licensed, they can go out and advertise their platform. They can they can drive traffic there to the website or the portal. One of the things they have to be sensitive of is that they're not promoting any single issuer. It's okay to mention issuers on their site. It's okay to advertise and say, hey, to highlight issuers, but the line they have to walk is they can't be paid to try to promote these offerings. Now, that being said, my inbox gets flooded every day with emails from licensed portals that are saying, hey, if you check out this company, check out this company, check out this offering.
So there's a lot of gray area that case law hasn't defined for us better. And so we see current portals potentially stretching the guidelines already.
Yeah, and I don't know if they're stretching. I think it's just uncharted territory. And I think we've talked about this previously, but the SEC has been surprisingly willing to work with platforms, work with portals, and I think they've been pretty liberal in their applying, tradition. A lot of things that initially as securities lawyers and crowdfunding lawyers were saying, oh no, you can't do that. We've had calls with the SEC and we're seeing people doing those types of things. Do you want me to go into, I think the second, third, fourth part of your questions is, hey, what can...
If there's significant distinctions that are on the top of your head, I think it'd benefit others. But if it's a jumbled mess and it takes a lot of thought, I will relieve you of that pressure.
No. I'm not sure how to take that. So, I can go down the path of what can, after a launch of funding portal under Reg CF, they can advertise the existence of their portal, and they can highlight certain issuers, but they have to sort of be, they can't be compensated to highlight one issuer over another. It has to be based upon criteria that they're applying in a democratic fashion, I guess. Do you want me to talk about what issuers can do during a campaign? Was that part of that question?
Yes.
Okay. So issuers, going back to what I said before, issuers prior to filing their Form C cannot say anything. They can't engage any sort of marketing. Once the Form C is filed with the SEC, the campaign is live, they can do two types of advertising. One is a tombstone communication, which is basically, this is who we are, this is what we do, this is what we're doing, this is the terms of the offering. We're offering, convertible debt, we're offering equity investments. They can talk about the basic terms of the offering. They can provide, factual contact information about the issuer, a brief description of the business, and then a link to the portal where that offering is taking place. They can also do what are called non-terms offerings, and this is where we get into, this is where I get most of my questions about this. You can talk about the offering so long as you don't mention the terms. So you can say, become an investor, or become an investor in X company. Investor means, you could be a debt or equity investor. You're not talking about the type of security that's being offered. There was one on a thing that, just something about the company, more information.
Could there be calls to action? Could you say invest now in XYZ?
Yeah, that's fine. As long as I had a client ask, could you have a banner ad that said, become an owner in, or own a piece of the action or something like that in this company. Become, an owner of the next something. There was two things that I didn't like about that. One is owner implies that you have equity. So that's a term of the offering. The other thing I didn't like it about is any time where you say we're the next anything, because usually nobody says that we're the next company that nobody's ever heard of. They'll always say, hey, we're the next Facebook, we're the next success company that they're trying to tag onto. That's dangerous for other reasons because that's misleading and potentially fraudulent.
So let's change gears a little. So talking about Reg CF, can affiliated people, not the owner of the portal, be compensated for deals on a Reg CF portal? So can affiliated person of a funding portal, Reg CF, use funding portal to raise money when the funding portal is not benefiting from the deal itself?
So can they pay affiliated persons?
So there's a person that wants to use the funding portal. So I guess it's, hey, buddy, let me put my deal on your portal. Mm-hmm. You're going, okay, I'll let you post it on my portal because I'm your friend, but the funding portal is not getting compensation. Can that affiliated person receive compensation? Is there any mechanism for them to receive compensation for the funding portal?
So we're talking again, if you're using the term funding portal, we're operating under Reg CF.
Correct.
And I say that just because there's a possibility there. Under Reg CF, you cannot pay commissions to anybody unless they're a broker dealer. So, and that's true generally, right? A funding portal couldn't pay commissions to this person for promoting their deal on the platform. A funding portal can, however, pay, they can pay broker dealers commissions. They can also pay, outside marketers to promote their funding portal. They just cannot pay them for providing personally identifiable information. They can't pay them for investor lists. They can't pay them for, hey, we're going to drive these people there, and they're paying them for that information. They can pay them to market and advertise, just not for that information. Did that answer the question?
Yeah. So
as far as you're concerned.
So let's switch gears a little here. Our next question, I think I get all the time. I assume you get quite often as well. It says, I'm starting a crowdfunding platform soon. So I have the idea of crowdfunding. I'm drinking the Kool-Aid. I would like to know what I need to do to legally when offering such a platform. So what's missing is the business model. What's missing is what type of platform. But they still want to know, okay, where do I start? So knowing that it's very difficult to answer such a general question, because it really depends on, well, what are you trying to do and how are you trying to do it? And then based on those answers, we could be more definitive on potentials. Let's go over some basic models from a BD perspective or a non-BD perspective of models people may want to consider when putting their feet into the crowdfunding water of, okay, I have a clean slate, guide me.
Yeah. And again, that's without the business model. That's without, what type. And I do get this question a lot. So do you. And the first question that I'll ask is, what's your focus? So what type of deals are you going to be doing? Who do you want to attract? What type of investors? And what is the size of the deal? So, for example, it's a company that says, hey, we want to help fund startups. We're an incubator. We want to help raise money for these startups. Okay, great. What size are the offerings? Okay, from that.
Over $1 million or under $1 million?
Under $1 million. So based on that, okay, they're smaller offerings. All right, well, great. Then Reg CF deals might be good for you. Okay, well, what does that take? Well, in order to do that, you've got to be licensed with the SEC and FINRA. So then the question is, okay, well, what does that entail? And so we go down that step, and they say, okay, well, it's going to take me, several months to go through. How do we get there faster? And then I talk to them about, okay, well, you can do deals under 506C to accredited investors. And then a lot of times the second question is, well, can I do both at the same time? And I start with one, and then once we get approved with the SEC, can we do both at the same time? The answer is yes, you can, and we'll help you figure out how to do that. So that's typically the line I go down. Sometimes I'll call, somebody will call and say, hey, we're thinking about doing crowdfunding. And I realize, and I'm sure you get this too, Brent, they say, well, we want to do a crowdfunding, we want to be a platform. And you realize that really what they're trying to do is they're trying to raise a lot of money for maybe a fund. They want to, the more we drill down on it, they say, you know what, we've got all these real estate projects that we're looking for financing for. And we want to be able to, buy certain assets. We want to be able to do some lending. We want to be able to do these things. And I'll steer them and say, well, you don't really want to be a platform. You want to do, you're looking for a funding source for all these types of projects. You might consider putting together a real estate fund, and we could do a Reg A Plus offering for that. And
what's the advantages of that? Because I get that call all day, every day, right? It's whether they want to do individual, like a fix and flip type of model where, hey, I'm touching 5, 10, 20, 50 deals a month, but they're all sub 100,000, 200,000. They may have accredited investors. They could certainly have space for unaccredited investors. And they usually have more opportunity to buy, but they also have to have funding very quickly. They can't afford to post a deal and wait 2 months for that deal to fund. They have to have that escrow closed within usually 30 days of them doing it. And so, quite frankly, the crowdfunding model doesn't work for that quick a turnaround, for that predictability, for the deal to fund that quick.
Yeah.
Right.
So in that case, it might make sense to have, hey, let's create a fund where you have these, where you have capital to make those quick type of investments. So, you go out and raise $5 million or $10 million or whatever it is to go and do that. And crowdfunding might be an answer for you, or Reg A Plus might be the answer. You've got to go through the SEC and FINRA. It's going to take time to do that. It's going to be more expensive to do that, especially if you're dealing with an attorney who it's their first rodeo and you're paying them to, you're paying somebody that might be a great securities lawyer, but it's the first time they've done it, and you're paying them to learn how to go through that process. But that's a possibility. I will say, and I say this to everybody that calls me, with any of these things, crowdfunding is, you've got to ultimately figure out how you're going to drive the traffic there and the investors there. Great, you have a Reg A Plus offering, you go through that process, we file it, and then it's crickets because you haven't thought about how am I going to drive investors there. And so
do you have to be a broker dealer to do a fund? Do you have to be a broker dealer to do the model you just talked about? Because usually there's the concept and then the question of, when do I have to be a broker dealer and when don't I have to be a broker dealer, and how do I know? And if I ask half the industry, they tell me one thing. If I ask the other half, they tell me the other thing. And Brent, I'm really confused. This is my typical conversation. Could you share any light on that?
To have a fund, do you need to be a broker dealer? No, absolutely not. And you typically wouldn't be. Does it make sense to use a broker dealer to help sell your fund, especially a Reg A Plus? Yes. Do you have to? No. But
why do you say that? Just to give some color behind your answer.
Again, and it goes back to what I was saying before. You've got to be able to sell the deal.
It's
right?
For syndication purposes, because that broker dealer may be connected, it may be worth hiring him for his expertise to bring investors through the door.
Yeah.
And so whether you're paying a marketing person or you're paying a broker dealer, it sometimes facilitates the deal being funded. Exactly. And so what you're saying is, while you don't need to be a broker dealer, leveraging the expertise of a broker dealer may be strategic and of value, and depending on the merits of that broker dealer and the cost and what they're taking, may be worth the exchange.
Absolutely, because at the end of the day, you're approved with the SEC, approved with FINRA, and your 5110. You've got to sell it, and it's great. You've got it up on a website. CrowdEngine's to build out an awesome platform for you. Everything's there, but the eyeballs and the investors. If you have that marketing expertise, or if you are a company that has 100,000 or 1 million customers already, and you have the ability to say, hey, go check out our Reg A Plus offering, become an owner in this company, then, broker dealers and as long as you're not paying anybody a commission along the way, it wouldn't be needed. But most people, like, for example, we've been talking about funds. Most of those funds don't meet that criteria. They need to figure out they need help in raising that money. And so it becomes a cost benefit analysis, and you talk to broker dealers and you figure out how much it's going to cost you, and you say, okay, does that make sense?
Great. So let's talk about 506B, because it's always a common curiosity or even concern of, when I have a 506B, 506B has been around for 80, 100 years, whatever that number is, and yet crowdfunding's only been around for a few. So why is suddenly 506B legal to do online? What changed? right? And why is it legal? What do we have to do to keep it or make it legal? Let's just talk about that for a second. So if I have a 506B offering, how does it have to be set up in a portal to be quote unquote legal? And what makes it legal?
Yeah. So and I get this question periodically as people are starting platforms, and there are still, especially on the real estate side, there are platforms that are still operating under, or still, that chose to operate under 506B. And, and I will talk maybe the benefit of that in a second, but 506B is basically an exemption. It's the safe harbor under Regulation D for private offerings. The Securities Act 482 says that any offering that's not a public offering is exempt. And that created all sorts of confusion. And so there was case law about, okay, well, what criteria needed to be met to be a private offering under 482. So they introduced a safe harbor under Regulation D, which is 506, or 504, 505, and 506. Most people use 506. And then the Jobs Act delineated and basically split 506 into 506B and C. 506B is again a private offering, and it's an exemption from registration. Under 506B, you cannot generally solicit. That's the key difference between a 506B and a 506C. So what does that mean if I have a platform? Well, that means you can't show your deals on your site to the general public.
So you get to claim your platform. You cannot claim the deal on your platform.
Here's what people do is you'll go to a platform and you'll see examples of deals that they have on there, but there are no terms. You'll see a picture it's blurred. I've seen people blur out a picture or not have a picture at all, and it might say multifamily housing in Texas. Okay. Based on that, you're not really offering, you kind of have some ideas of what it is, but you don't have any. That's sort of this slippery slope gray area that we get asked to push all the time. What those platforms do is under 506B, you have to establish, and I think we've talked about this previously, a pre-existing and substantive relationship with the investor.
Let me interrupt. Does registration equal relationship?
So you asked what changed. There was a series of no action letters from the SEC that have been come out over the last several years, and they provided some guidance and really said we're going to focus on, we're going to look at this kind of a case by case basis, but pre-existing, and we're going to focus on the substantive issue. And there was always this time frame. Well, how long is the pre-existing? Is it 30 days, 45 days, 60 days? And what they said is we're going to focus more on the substantive relationship. So a lot of times people do, to answer your question, you'll go on, you'll register with that site. Now you're not immediately given access to the deals. That's when the time clock starts. Okay. What some people do there is there's contact. They might be a telephone call. There's some emails. There's this series of things that the platform does, or the issuer does, to develop that substantive relationship. Once that's been established based upon a combination of time and contact substance, that person then can view the deals, view any deals going forward from that time. They can't invest in deals that were existing prior to that relationship being started, but they can invest in deals that could come after that.
So if I go live with a deal today, mm-hmm. and someone walks through the door next week under 506B guidelines, it's your interpretation, they cannot invest in my deal. It has to be the next deal.
Yes.
Interesting.
Yeah, and that's something, I've talked to other securities lawyers in this space about that, and it's something I was hoping, and we had one client that we didn't go down the route of asking for a no action letter because I talked to enough people that realized that was going to be futile. But I thought, well, maybe there's an argument that that you might be able to, the offering means the offering to that person, And as long as they can't see it, you didn't make any offering to that person. But I've been told that, by a few people that weighed in that said no, offering means just the offering in general. So because you might have been able to hear about it from a friend or something like that. And so anyway, so that's a 506B. A 506C, obviously you can show the deals. A 506C, you can have the deal, all the terms up. Anybody can see it. The limitation though is you have to be an accredited investor. And in both cases, I think both cases is really, although a 506B, you can have up to 35 non-accredited investors. I think most platforms are only accepting accredited investors. The big difference there is under a 506C, you have to prove that you're an accredited investor. You either have to use an outside verification source, or the issuer has to, receive tax returns or a letter from their accountant or their attorney or financials or something that proves they're accredited. Whereas under a 506B, the rule has always been you check the box and say I'm an accredited investor, and that's sufficient.
So here's a change of speed. Can a U.S. company use Reg A Plus if they have or will have a significant part of their business internationally? So does the amount of business they do internationally influence their ability to raise money in the U.S.?
No, that shouldn't be an issue.
As long as they're a U.S. based company.
As long as it's a U.S. based company, because it's a U.S. exemption, it applies to U.S. company. So that's a good question.
If a broker-dealer portal is raising money from funds from several states under Tier 1, are to require to give notice to each state also? So I guess this is a Reg A Plus. If a broker-dealer portal is raising money, funds from several states under that Tier 1, is it required to give notice each state and also go through the required coordinated registration process?
Yes. So
let's pause it. These are all the reasons why you're not going to do Tier 1 and you're likely going to do Tier 2 if you're doing Reg A Plus.
That's what I would suggest. The main difference between Tier 1 and Tier 2, Tier 1 has some dollar limitations, but the biggest difference is just that under a Tier 1, although you're not required to provide audited financials, which maybe to some people that's prohibitive, you are required to provide notice filings. And not only notice filings, you're required to coordinate registration with each state that you're conducting the offering in, which that is
nightmare,
time-consuming, a nightmare. Now, I know they're trying to make it so that the NASAA the State Securities Association is trying to, there's been discussion about coordination of registration. I don't know how well that's working, and I've never personally tested that. I think you're going to spend a lot more time and money trying to do that than you would just going and getting an audit on your financials.
Yeah.
So, that's something that the audit can be done while you're working on your 1A and working on that filing. Whereas, if you're trying to coordinate that registration and get approved by each state, and each state's coming back with comments, it's a nightmare.
Yeah. So the general census of everyone I've talked to is skip Tier 1, go directly to Tier 2, or don't use Reg A Plus. If it's that big a deal, then go Reg CF or Reg D, because it just doesn't fit.
Yeah.
So here's a question. You're building a portal, Title II offerings for the next, let's say, 6 or 12 months. You eventually plan to go to Title III later for a Reg CF. Can you have, and I guess if you only do 506C, can you have non-accredited investors register with the premise of letting them know that you're going to have opportunities for them later? Is there any law that prohibits unaccredited investors from registering on your portal?
I think that would be okay, because as long as those issuers as long as the issuers are different, where I think you would get into trouble is you have non-accredited investors, you have, an issuer that's going out and doing an offering for their company, and they, start their 506C campaign, they're gathering all the names of these people, and then as soon as the platform's up, they start a Reg CF.
So the platform's already there. They're going to do a Reg D Right, but see, it's a portal. The
Yeah.
portal's collecting the names and registrants, not the issuer, right? And so even if an unaccredited investor gives you money thinking, they lied on their accreditation and had their buddy sign the paper, whatever, and unless you break escrow, that's not breaking the law, right? You could return the money going, hey, you're not accredited, no harm, no
Well,
foul. And then eventually you're going to go through the Reg CF process, get approved for Reg CF. The question is there any liabilities or damages of having all these unaccredited investors on your portal that you've naturally attracted through your 506c general solicitation, right?
So, and I think that's okay. I mean, other people did that. There have been a few of the platforms that were doing 506c, and then they, developed they have a database of all the people that have registered, and they're marketing to those people now. I don't think there's any problem with that. Like I said, where I was going with that is it's more an issuer concern that you're not using a 506c to condition the market or quote unquote to test the waters before doing a Reg CF offering. That's where I would be more concerned.
Yeah, so it could be on the issuer level, but not on the portal level. As long as the issuers aren't manipulating different offerings, then you're fine. But if it's looks like a masquerade for an issuer to use a loophole, then you might be in the crosshairs.
And that being said, it is possible to do a 506c offer, an issuer do a 506c offering, and then a subsequent Reg CF offering. There just has to be some sort of cooling down period. You want to be careful not to do a Reg CF right on the back of a 506c, just because again the pre-offering communications, those could get integrated and blurred.
So the next question is, we are essentially a real estate equity syndicator, not a broker dealer, and we file whatever we need to file on the blue sky laws. Then what do we need to do differently, legally speaking, if anything, to operate a crowdfunding platform that is offering 506c or B opportunities online? So they're talking about being a syndicate for equity real estate. They're going to file with the states or the blue law. Why don't you explain that for everyone and kind of diagnose it?
And I actually love hearing from groups like that because they've been doing this, right? This is something they fully understand. Real estate guys that have been doing syndication, what I tell them is that this is just the natural, technological progression of their business. They don't have to do a lot different at all with respect to what they're doing. They just have to, again, they're providing disclosure. I presume they're providing disclosure materials when they're doing those syndications so that they're compliant with 506. They're filing their blue sky filings, which you need to, do under a 506B or C. So that's the same. The only thing I would say is that if they're, doing an offering under a 506C or B, that they're not, mixing those two up and with respect to how they're promoting those deals. But, guys that are doing real estate syndication, it's an easy conversation and understanding to go to crowdfunding, because really all crowdfunding is it's doing what you're doing before. You're just doing it on the internet.
Great, thank you. If you're only doing Title II offerings, do you still need to reserve your name with the SEC? If not, how do you ensure that your name is reserved?
You do not need to reserve your name with the SEC if you're doing Title II offerings. And you actually reserve your name with FINRA that you'd have to do that on a Title III or Reg CF.
Let me restructure the question, because I think that's what they're asking. I'm XYZ Company Incorporated or XYZ Portal, and right now I'm only doing Title II. I plan in the future to do Reg CF. When is it appropriate for me to register? If someone punches in and registers with FINRA XYZ before me, even though I have my Title II portal, does my Title II portal reserve my Title III spot in line? And that's, I think, the question is, if you plan to do a Reg CF portal,
at some point,
it's up for grabs until you reserve it.
Yeah, and the nice thing is, so you reserve it, and then you have 120 days to take certain steps with FINRA, and that doesn't mean you have 120 days to become a portal or even file what I've learned, or even file your your Form FPNMA. You just have to take certain steps to become registered with FINRA not approved. But yeah, so I would suggest if you plan to do it in the future to go ahead and reserve that name sooner rather than later. Otherwise, if you're just going to be a 506c platform, how do you protect that? Trademark laws are there to protect your goodwill and the name that you have. So
if you're raising money, you have a startup that wants to leverage Reg A Plus, and they don't have any books to audit. Is Tier 2 still an option?
yes.
Why?
There's plenty of startups that you can still get an audit, even if you have no assets. Even if they're auditing a checking account that has a few $100s in it, you can still get an audit. I'm working with a few companies now that they're brand new real estate funds, and they, all the auditors are auditing their checking accounts.
Yeah, I believe I saw one that their bank account was $17.
Yeah.
Upon approval. So there was clearly no assets in the company, but yet they were still approved. So absolutely. If you do a 506B offering and therefore need a 30-day cooling off period, can the investor register on your portal, see the actual deal, and then invest in the deal after 30 days? I think we already answered this, so let me see if I could answer it directly. So as Marty said, on a 506B deal, to his interpretation, if the relationship started after the deal has already been posted on 506B, that person would not be allowed to participate in that offering. It would be the next offering on the portal, 506B offering, that they would have the ability to invest in. Also, I believe the letters from the SEC no longer require a 30-day cooling off period because they're not using that as the measure of establishing relationship. Correct?
Yeah. And again, it wasn't, the clarification is that there's no bright line to say it's 30 days or 45 days. I still recommend that. I still think it makes sense because you have to have this pre-existing relationship. The longer that relationship is, I think the better that's going to bode for you. But the question there is, you've got offerings on your site, and I go on as an investor, there needs to be some sort of period of time. And it's not necessarily, it's sort of a, get to know you period.
So let's play this out. So let's say you have a portal out there that decides to push it. They have a cool off period of 24 hours. They let someone in a deal that was already posted when they had it. They take their money, the deal funds, everything, everyone's high-fiving each other, hooray, hooray. The investor's happy, issuer's happy. What happens? When does it fall apart? When do hands get slapped, fines get sent, and people go to jail?
Well, I don't know. I going to jail in that point might be a little extreme, but I guess the risks are, okay. So one, the biggest risk there is that they blew their exemption. They allowed somebody in that they didn't have a pre-existing relationship with. So they blew their exemption from registration.
Which means what?
Which means they just offered they had an unregistered securities offering, which, again, is against the law. Most likely what would happen if everybody was all, like you said, high-fiving, the deal's good, and everybody gets paid back, most likely nothing's going to happen. The SEC doesn't have the time or resources to go and try to police every single deal. But let's take that. But
when the investor loses money,
exactly.
Now that it gets really thick really fast.
Yeah, that's where they get in trouble, is because now the investor says, "Hey, you had an unregistered securities offering, and you brought me in under this unregistered securities offering, and you didn't comply with what you said." Now the investor has a cause of action against that issuer.
Do the other investors have a cause of action? Because
they would.
And so
yes.
Not only do you risk one investor, but now you risk 30 to 100 investors, maybe 1,000 investors.
Because your exemption's blown, yeah. And the typical remedy there is it's a rescission. So basically it's, okay, you have to give me my money back plus some sort of reasonable interest rate that I could have earned on that. So now, everybody's high-fiving the deal's good, and now you're having to figure out, how do I get these people back?
The $5 million, $10 million that was already spent, that's not in your bank account anymore.
Yeah,
now you have to scratch and pull and go, okay, even if I liquidate the asset, it might not be ready to be liquidated. It might be only worth $3 million on the market.
Yeah.
And now you have real problems.
Yeah. And at that point too, the SEC
involved.
They get involved, or the state, and they say, okay, well, we're here to protect the investors. So then, the SEC starts looking at it, and then the fines and so forth. So that's the parade of horribles that follows.
In a very real way, unfortunately, nothing happens immediately.
Yeah.
It just has a very long tail of liability. And so even though you might be high-fiving all the way to the bank for the first 6 or 12 months, typically when there's a bump in the deal and the investors get excited, then they're looking for the loophole, how to get their money back. And unfortunately, in your rush to get funded, you gave them the loophole to really potentially take advantage of you.
Yeah,
because even though they're the ones begging to get in the deal in the first place, look the other way, let me in, let me in, let me in. Now they're holding you responsible for you being nice or stretching your own moral guidance.
Yeah, exactly. There was an attorney I worked with when I first started practicing. He said, so many people in securities, they fall under the good deal exemption, meaning the deal goes well, it doesn't.
You do a lot of things wrong.
Yeah, you can do a lot of things wrong, and it covers that. But the second something goes bad, the investors, and more importantly, the plaintiff's attorney, the attorneys, they're going to try to find out where you screwed up. And that's why it's important that you do follow the steps, that you follow the rules. That's why it's important that you have, disclosure material, that you talk about the risks, you talk about the deals, and that's an insurance policy for you to, going back to the syndication question, as long as you're disclosing those deals, whether it's a 506B or 506C deal, as long as you're disclosing those risks and the information, and that you're doing that to protect yourself.
Well, quite frankly, this is one of the major reasons why we're having this webinar, is to educate people on the realities of raising capital securities in the U.S. and the things they have to be careful of, and so they can configure their portals and manage their business appropriately to stay clear of the problematic areas. And so while every individual has the ability to make bad choices, even in the rush to get something funded, it will typically, in the end, not serve you well, because eventually something was going to go wrong somewhere, and then it quickly unravels, and that's what we all want to avoid. That's it for this month's webinar. Marty, thank you for coming down and visiting with us. If any of you had a question that did not get asked, please feel free to email me directly or Marty directly, and we'll get that answered for you over the next couple of weeks. And have a great week.
Yeah, thanks, Brett.
Take care.